I have a question for you. When you read something and you're not sure exactly what it means, where do you go for clarifications? I go to the person who wrote it, but apparently not the federal courts. Today we'll look at a case that challenges this process. Next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Well, hello there, everyday Americans. Paul Engel here once again with the Constitution Study, where we read and study the Constitution and teach the rising generation to be free. I'm glad you could join me today. As always, head over to the website there, constitutionstudy.com, for all things about the Constitution, a little about the Constitution Study, all that I'm working on, all the places I'm going to be, all the events I'm participating in, mostly for feedback. I've got a couple questions coming up I'm going to answer in episodes in the near future. I love when that happens. So please head on over, find out what's going on, ask a question, participate. I also want to thank everybody that helps out at the Constitution Study. It's mostly, I do most of the work here, but there are a lot of people that help out in different ways, getting the message out, sharing the message, giving me a voice to bounce ideas around off of. I want to thank especially Mark and Carol Murphy. In fact, Mark Murphy has a band called Rebel North. I use their music for my bumps. Head over. They've got a new website, rebelnorth.com. Buy their CD. Help them. They have helped me tremendously in getting the message out. So I'd appreciate it if you go over and visit them and talk to them as well. I'm also working on my schedule for conferences, where I'm going to be speaking, where I'm going to be presenting in the next few months. I've got a couple things coming up later in the year. If you have events that you would like to see me at, head over to the website. Let me know. I love getting out in front of people and talking about the Constitution and all the wonderful things that we can do if we actually knew what it said. So let's see. Today's episode is about a Supreme Court case I stumbled across called Kisor versus Wilkie. And in this case, there's a Marine veteran by the name of Kisor, Mr. Kisor, and he's been trying to get benefits for his duty-generated PTSD. Now, back in 1983, the Department of Veterans Affairs, the VA, denied Mr. Kisor. They denied that he had PTSD. Then in 2006, he successfully appealed his decision. He went back to the VA and said, yes, I have PTSD. Here's the evidence. Here's the documentation. They said, yes, you have PTSD. What is important to this case is that Mr. Kisor included material that existed in 1983 when he was denied benefits, but they apparently weren't used in his case. Now, why is this important? Well, it has to do with the wording of the law. See, if the documents, the law says if relevant documents existed at the time of the original denial, then Mr. Kisor's benefits would be retroactive to his original denial. Right? So if the documents existed but they weren't used, then his benefits go back to 1983. Otherwise, his benefits would start with the approval of his appeal in 2006. Now, that's 23 years worth of benefits. And in my book, that's a big deal, which is why Mr. Kisor has filed this lawsuit and why apparently it's gotten all the way up to the Supreme Court. You see, the lower courts found that both Mr. Kisor and the VA had reasonable views of whether the documents were relevant or not. They both made good arguments, but there's a tie. So what happens when the court isn't sure how to interpret a statute or isn't sure how to apply a statute? Who decides? Well, surprise, surprise, it goes back to precedent. And in this case, the Supreme Court precedent of two cases, Bowles versus Seminole Rock Sand and Sand Company, and Auer versus Robbins. See, now, both of these cases establish a precedent that the court should defer to the agency's interpretation as long as it was reasonable. But the question to me is that just? And even more important from a constitutional standpoint, is that due process? Is that protecting the rights of all involved? Now, most of the arguments in the Kisor case that I reviewed revolved around two basic questions. One, would the courts or the agencies be better able to determine the correct answer? And two, how disruptive would it be to overrule these precedents? You know what I didn't see in any of these discussions? Trying to determine the intent of Congress. What was the intent of the people who actually wrote the law in a situation where it wasn't sure of whether or not the documents were relevant? What was Congress trying to do with this law? So, as I said, much of the discussion dealt around who should break the ambiguity revolving around technical knowledge of the issue at hand. In fact, Justice Breyer said, but as a practical matter, you've read the SG's, the Solicitor General's brief. I mean, there are hundreds of thousands of possibly millions of interpretive regulations. I mean, they give an example of one of them where the court deferred to the understanding of the FDA that a particular compound should be treated as a single new active moiety, which consists of a previously approved moiety joined by a non-ester covalent bond to a lysine group. Do you know how much I know about that? Which, of course, generated laughter. Now, here's the interesting point. At least from my standpoint, both the courts and the VA attorneys said the executive agencies have better technical knowledge, so they should decide. Now, Justice Breyer set up a straw man. He took a really out-of-the-way, esoteric situation where there was a technical decision, and the courts decided to listen to the FDA. He didn't bring up any information about what I'm assuming, plaintiff in that case thought. Was their technical knowledge not as detailed? Right? Just because the agency may have more knowledge than the justices doesn't mean they have more knowledge than the other party in the case. This opinion, expressed both by the government and Justice Breyer, assumes three things. That the question is one of technical detail. The issue is a technical one. And he used the FDA and moieties and words that most of us have no idea what it means. I don't know what a moiety is. I have an idea of a covalent bond. He used a very detailed technical situation and assumed that the issue is always a technical one. They also assume that the executive agencies have no agenda of their own. And third, the courts, who apparently don't understand the topic, would find that the agency's interpretation was reasonable. Well, if they don't understand the topic, if they don't understand the issue at hand, how do they know if their answer is reasonable? I spent 30 years in the IT industry. I could explain to you in technical detail how certain components of a computer system or a server group or a data center work. And if you have no idea what I'm talking about, how do you know if what I'm saying is reasonable? If I tell you computers work because magic smoke is stuck inside, and if the magic smoke comes out, they don't work, well, that seems unreasonable. But could I not turn around and say that because of the speed of light, computers are limited by a certain performance aspect of electron traveling across a trace? How do you know if that's reasonable or not? Unless you've worked in that industry. See, in other words, did the agency find Mr. Kisor's document irrelevant because of their technical expertise, their technical opinion, or because it led to a more just outcome? Is such an interpretation reasonable? Do those at the VA making this decision, do they have a vested interest in the decision? Is there a reason? Do they have a vested interest going, well, it would hurt our budget. We don't want to look like we made a mistake. Whatever. That is never questioned. That's never considered. That's like saying in a baseball game, when a foul ball is called, the umpire should defer to the home team's interpretation of what a foul ball is. See, there's a rule book that says what a foul ball is. Well, we're not entirely sure. It hit the pole. It did go inside. Did it go outside? We're not sure. We're going to listen to the home team. Does that sound fair to you? Further, and even worse, this is the one that really, made me go, "Arr," was the other question repeatedly raised, and that was how much work overturning Orr and Seminole Rock would make for the courts. How many cases would have to be relitigated? Justice Ginsburg said, what about the lower courts? Let's say your argument is accepted and Orr is overruled. There may be a dozen or so cases, or cases in this court, but there are probably hundreds in the lower courts. So do all of those cases, what happens to all of those cases where there was a reliance on Orr in the lower courts? See, in my mind is a better question. What is the purpose of the court? Is the purpose of the court to seek a just outcome, or just to make sure there's not more work for the judicial branch? If the precedents in Seminole Rock and Orr lead to an unjust outcome, shouldn't the court be more concerned with getting justice than just how much work they make? The most important question was never asked. What was the intent of Congress? See, I've been told that lawyers are taught whenever there is an ambiguity in the text of a law, the intent of the legislature should be determined. It's one of the reasons why Congress records, and I believe every state legislature records, all that is said in their chambers, the congressional record, so that people can go back and try to understand the intent of the legislature, not simply if the words don't help. There's this little thing called I never thought of that. There are situations I'm sure Congress never thought of when they wrote this particular statute. So they did not include specific language of what happens if both the person and the VA have a difference of opinion about whether or not the document is relevant. Why not go back and find out what Congress wanted to do? Why did no one go back to the debates in Congress to determine their intent? Personally, I believe it's because we've become judicial supremacists. We think the courts are the most important. Well, if the courts can't figure it out, it's the same reason Justice Breyer said if we don't understand it, we're going to go to the agency and what? Ignore the other party to the case? Is that due process? What the courts have effectively done is they're legislating that the bureaucratic agencies can legislate as long as the court finds it reasonable. The court has allowed the agencies to effectively place their thumb on the scales of justice. That is not what the judicial power of the United States was designed for. See, I'm not at all surprised that the federal government would defer to their own opinion. See, remember, the federal courts, including the Supreme Court, are part of the federal government. They are the judicial branch. They are one of the three branches of government. So the court preferring the agency's opinion is the very definition of a home field advantage in the courts. We should be asking ourselves, is this how we think courts should be acting? Giving over-deference to other federal agencies, to ignoring the due process or the information, or at least diminishing the value brought in a case because it wasn't brought by a federal agency? Is that good behavior? Remember, federal judges serve during good behavior. Is this good behavior? Is it good behavior to put the thumbs on the scales of justice, to give the federal government a leg up in the courts? See, hopefully one day the courts will get beyond this slavish devotion to their own opinion, to precedent. That's what it is. Their devotion to precedent is their desire not to change their mind. Well, I think this may be wrong, but precedent says this is okay. not only for Mr. Kisor, but for everyone who has been caught in the gears of our bureaucratic government. It's time we went to our hired representatives and said, it is your job to look at the courts and keep them in check. That's part of your job. The House of Representatives determines what is an impeachable offense. If the courts are going to set aside a just outcome in favor of an outcome for the federal government, if the courts are going to set aside a just outcome just to avoid making more work for themselves, that is not good behavior. And it is time our hired representatives start holding those judges accountable for their bad behavior. And the only time they're going to do that is if we, the people, hold them accountable for their bad behavior. So I hope you see this is, it's a little case. It's not a big, breathtaking case. It's just a poor guy trying to get the benefits he believes is due. He's trying to get a redress for his grievance against the VA. And he comes across a system where the scales are stacked against him. Maybe if we worried as much about Mr. Kisor's rights, his right to due process, his right to a fair trial, if we ever find ourselves caught in the gears of our bureaucracy, somebody will stand up for our rights. I hope this made you think. I hope that's what these are all about, waking people up and thinking. I hope you'll do a little research. I hope you'll follow along with this case. You can head to SCOTUS blog, and you can follow the case yourself. Most of all, I hope we are seeing that this devotion to the Supreme Courts, to the courts as a whole, the devotion to their own precedents, is damaging to the Republic. It's dangerous, and I hope you'll start talking to your representatives and to your state legislatures and informing them that you want them to uphold their oath to support the Constitution, and that you're going to expect that of them if they want your vote. It's time we, the people, regain control of our governments, and it's only going to happen when we learn what they're supposed to do. And when we look at these cases where we're not involved, we're looking at the rights of somebody else. But if we're not going to protect other people's rights, why would we expect others to protect our rights? So I hope you enjoyed this. I hope you'll follow up on it. And most of all, I hope to see you next time on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from